Lisa, I should wait for just a few minutes for that those members to populate.
Yes, we'll bring in the committee members, and Mimi has also joined, and so she will take it from here.
Ms. Harvey, you ready? Are you ready?
Yes, Chair, I'm ready.
Very good. Very good. I'd like to call to order the meeting of the State Bar's Finance Committee and welcome my fellow sort of board members as well as members of the public that may be tuning in. And as a reminder, this meeting is being recorded. Ms. Harvey, can I get you to call the roll, please?
Broughton.
Here.
No.
If you said no, I'm here.
Seleg. Sol.
Present.
Tony.
Present.
We have a quorum.
Very good. Very good. Now I'd like to call for public comment. We'll just sort of note that any member of the public, this is your time. If you have comments about agenda items that may be before the committee, now is the time to step forward with those public comments. For those of you who are on Zoom, there is a raise your hand function that will allow you to be recognized. For those of you who may be calling in by phone, I think you should press *9 in order to do so. Ms. Harvey, any members of the public wishing to comment on any of the Finance Committee agenda?
We have one hand raised. That is Todd Hill.
Okay. Mr. Hill, you are recognized for 3 minutes.
My apologies. I have tried to keep each point specific to the committee to demonstrate that I do have some respect for the process. So in this particular case, I recently received a response to a request for an antitrust determination related to my school's ability to operate contrary to law for multiple years in assigning basically lower units to folks who pass the baby bar so they can't transfer. That's a market restraint, right? Because they can't actually go from place to place to place to place, right? So what happens is that as long as the bar allows these guys to operate wantonly, they're actually giving them the grant of authority to operate wantonly under color of law. I've heard much talk of things like immunities, but the first mandate is protection of the public, regardless of your conflict of interest. And so when you receive things like determinations of antitrust, where there are simply per se Sherman violations of law, it's per se. Failure to respond to a preservation of evidence request. Failure to respond, the duty attached to every attorney when it was sent and delivered. In fact, the duty attached when you knew it was likely that there would be a lawsuit filed. I don't think there can be any immunity if you're in violation of the first mandate of the State Bar Act. I think that's a very coherent, easy to understand argument. Thank you, sir.
Appreciate your comments, Mr. Hill, and Ms. Wilson. I do. I trust that the bar is engaging in at the level that it does need to engage with Mr. Hill regarding his respective comments.
Yes, several arms of the bar are very actively engaged with Mr. Hill. I'm not sure we're gonna.
They don't seem to be. They don't seem to be actively engaged at all. And they don't seem to be the people that should be. It seems to be the conflicted parties still who are in control of the operation.
Hill, you're,
Mr. Chair, if I may, Mr. Hill, we hear you and your comments. My office has responded to your inquiries before on this particular antitrust issue. However, we will follow up with additional information based on the comments you have provided.
thank you.
Chair, we do have one more hand raised, and that is Betty Williams.
Ms. Williams, you're recognized for 3 minutes.
Thank you, sir. I guess point of clarification, the agenda, I did have the impression the agenda started today at 9, but you're saying at noon, it would be the full board on the topics of the 3 agenda items?
No, the finance committee, we will take up our agenda items. If your item is before the finance committee, you're more than welcome to provide comment.
No, mine has to do with the non-exam pathway issue.
So if I'm not mistaken, that is on the full board's agenda. That's the provisional licensure agenda item.
Right.
That item would be heard at the full board, and that does start around the noon hour.
Oh, in an hour. Okay.
Around the noon, around
the noon hour. Thank you, sir. I will call back. Thank you.
Good, very good. Look forward to your comments, Ms.
I
Williams.
appreciate your clarification. Thank you.
Ms. Harvey, anyone else?
That is all for public comment.
All right, well, let's move on with the agenda that's before us, the Finance Committee today. I think the first item that's up is the chair's report, and I really don't have much of a report other than to say that we do have several agenda items before us today. Most of them are dealing with fees in some form or function, and I think that's the extent of it. We'll try to move through it as expeditiously as possible. Next item on the agenda is approval of the minutes from our last meeting, which was in September. Is there any member of the committee seeking to modify or clarify anything that might be a part of the minutes that are before us today? Seeing none, might I get a motion to approve the minutes from the September 22nd, 2022 meeting?
I'll move.
I need a second, please.
Second.
So moved by Mr. Broughton, second by Mr. Tony. Ms. Harvey, will you call the roll, please?
Broughton,
Yes.
Noel,
Yes.
Select, absent, Tony,
Present.
is that a yes, Mr. Tony? I mean,
Present.
trustee?
Yes, sorry, yes. Aye,
Thank you.
forgive me.
Very good. Very good. I think the minutes have passed, correct, Ms. Harvey? You're on mute.
3-4, none against, the motion carries.
Very good. Next item on the agenda is the consent calendar. Is there any member of the committee wishing to pull an item off the consent calendar? Mr. Tony.
Yes, I would like to move the item onto the regular business agenda because this item is also on consent at the full board meeting. And it's important for the trustees to know that recommendations come from a committee that's reviewed the recommendations.
Very good. Ms. Harvey, if I'm not mistaken, I do have to call for a vote to item from the consent calendar. Is that correct?
That is correct.
No,
That's not correct.
No.
That is not correct.
Okay, very good. All right, Mr. Tony, without objection, absolutely. We'll move the item from consent to the regular order of business. Okay.
Thank you very much. I will tell you that my understanding is that anything can be moved from consent to regular upon request of any single member.
Got it. Appreciate that clarification, Mr. Tony. Would that then make that item the first item that we hear in the regular order of business?
That is correct.
Okay, and do we have the members of the staff present on this item present?
Yes,
Yes.
I'm here.
Very good.
Hi, I'm Dina DiLoretto. I'm the Program Director for Attorney Regulation. Thank you for having me. And thanks for the opportunity to intro the item and explain some points of highlight that I should highlight. This is generally a routine item, formally requesting the board's approval to set the 2023 licensing fees at the maximum amount permitted by statute, as well as related penalties for the annual billing and compliance cycle. Of note, something different from 2022 and accurately reflects a change in the statute, the $5 amount previously allocated for funding legislative activity and included in the fees and presented as an optional deduction will now be presented as an optional donation. Therefore, the billed rates for active and inactive fees for 2023 are reduced by $5 compared to 2022, bringing them to $510 for active fees and $177.40 for inactive fees. Also new for 2023, if the board approves a change to Rule 2.13 as recommended in Board Item 50-8, this item serves to incorporate a $100 penalty into the schedule of charges and deadlines for non-conforming payments. That is, paper check payments that are submitted without proper processing documentation. Also new, this item incorporates non-compliance penalties and reinstatement fees into the schedule for the newly approved CTAP program, setting them at the same amounts as MCLE non-compliance fees. And lastly, on a particular note, in an effort to streamline the board's process, instead of waiting until May, this item requests the board's permission now to set the final deadline for payment of fees for MCLE compliance and for CTAP reporting requirements as June 30th, and seeks the board's approval to proceed with the steps needed to suspend licensees or enroll as inactive for those who have not paid or are not in compliance with by that deadline, following appropriate notice, of course.
Very good. Thank you for that that presentation. Questions from the committee? You know what? I actually do have, Mr. Tony. I don't know if I actually do have one. As a non-lawyer and never had to pay these sort of licensure fees, when I see that amount of sort of $510 with a base of $390 and what appears to be some opting as to whether or not I want to pay for other or opt to pay other sort of, you know, as it relates to sort of the legal services assistance and those sorts of things like that. If I didn't pay any of those, would my the amount that I would be required to pay for licensure just be $390?
There's a few other items that are required but are separate from the $390. The client security fund amount is set in statute at $40. There's a discipline fund amount at $25 and a lawyer assistance program amount at $10. So the legal service assistance amount of $45 is optional. And within the $390 exists a $2 amount related to elimination of bias programs. So there's $47 that's optional. 2 of those dollars exist in the $390. 45 is a separate amount added. So it's $510 less 47 is the minimal amount, and I forget the amount off the top of my head, but that's the minimum amount required. So I think it's, yeah, 378, I believe.
Thank you for that clarification. Mr. Tony, did I see your hand?
Yeah, yes, thank you very much. And I really appreciate the opportunity to have this discussion here. So let me ask about the MCLE non-compliance and reinstatement.
Yes.
Are those amounts set by statute?
No, those amounts are set by the board.
Okay, so I note that the amount being recommended says that they're unchanged from 2022.
That's right. But at this meeting, you will be considering recommended changes for the future. In the case of the MCLE non-compliance fees, it would be too difficult to incorporate for 2023 because all the programming is kind of ready to go. So, but you will be considering changes for the future so that at next time we come for next year's fees, there's a potential it could be a different amount as the board.
And remind me what agenda item that is, please?
I think it's coming up next.
Yeah, it's just,
Oh, it is
That's
next.
Or
agenda
A.
item, Mark.
Very good, thank you. Okay,
My
and
pleasure.
then is that the same issue with penalty for non-compliance? I'm sorry, that's not the one I wanted. The fees and late payment penalties. Is that also the same? It says the proposed penalty amounts are unchanged from 2022. And that's my major concern, is that we've had issues with fees not keeping pace with the cost of administration. And so when I see that we have an opportunity to make a change and it's unchanged, I question that.
Yes, it's really the timing. Now that we're about 2 weeks away from live, opening the system with all of the billing, compliance, CTAP, new requirements and all those things, it's just late in the process to turn around and make a change to our system for 2023, unfortunately. But absolutely, I believe the next item addresses some of those concerns. Some of them can be addressed, can be made effective right away. A lot of the application fees will be effective almost immediately. But the fees associated with the annual licensing and compliance cycle, for which programming has been underway for the several months, unfortunately, it's a bit late to make a change.
Okay, so what November, I can understand, is too late for something that takes effect January 1. I get what you're saying. What month would be a good month for the finance committee to review this in the future so it wouldn't be too late?
The previously scheduled meeting is usually in September, and that would give us adequate time to incorporate changes that would affect the next
Super.
cycle.
Well, thank you. We sure would appreciate seeing this in September when we can discuss it and and our discussion have an impact. So thank you.
My pleasure.
any other comments or questions from members of the committee? Seeing none, I'd entertain a motion to move this item.
I move it.
Need a second. I think Mr. Broughton is.
Yeah, I'll second. I couldn't find my button there.
Gotcha. Very good. So moved by Mr. Tony, seconded by Mr. Broughton. Ms. Harvey, would you call the roll, please?
Broughton,
Yes.
Noel,
Yes.
select absent, Tony,
Aye.
that's 3-4, none against, motion carries.
Very good. Do we have the staff members present that'll be presenting on the regular order of business item A?
We do. Before we get started with that item, I just want to say that I think, Mark, you're making some good points because we are going to go over with you several fees that we have identified as warranting adjustment, but they are not all the fees that you see on your fee schedule. There's also an issue that all of the fees that we assess as an organization are not on that fee schedule that you approve. Okay, so there's two issues. We did not, for example, address the late fee that's assessed for payment of your licensing fees. There are other late fees outlined in this memo in agenda item A, but not a late fee associated with payment of your license fees. So you have asked for a more frequent cycle for reviewing of the fees. I think that's appropriate. I also think the board may want to set some policy, assuming OGC gives us the green light to do this, that some of these fees we just increase by some modest % annually, because we know that the underlying cost of doing business is increasing every year. So I think I just want to validate what you're saying. First of all, we need a schedule of charges and fees that reflects all of the fees we charge as an organization. And we need a systematic review of the fees that are non-statutory. There are fees that we can't change, obviously, like our primary licensing fee. So we're going to go over some fees today, but I just want to acknowledge that it is not all of the fees, certainly not all the fees that you just saw in the previous item. And
I'm sorry.
with that, I'll just hand it over. I see three
Ms. Wilson, can I
folks here on the
ask
screen.
you
I don't know who's starting.
One quick question though, about what you just said to regarding Mr. Tony's response to Mr. Tony, and that is there are some fees that are delineated in terms of the actual amounts in statute. But am I correct that there are also some fees with which we can only increase on a statutory schedule as well? We can only review them periodically, or am I mistaken on that?
No, not in terms of the frequency of the review cycle for the statutory fees. No, we don't have anything that governs how frequently or infrequently we need to review fees.
Okay.
But some fees need Supreme Court approval, and that issue is addressed in this present agenda item. Okay. So there's statutory, there's Supreme Court, and then there's ones that we can just modify on our own motion, so to speak.
Very good. All right, well, let's move on to, let's get to the heart of it then. Let's move on to
sure.
Item A.
Thank you.
Justin, is that you?
Yeah, I'm standing in for Araceli, who's not here today. So this is the next step in the process to raise these certain fees. The Finance Committee is asked to review staff's final recommendation for the law corporation, the MCLE compliance that we talked about, and the certificate of standing. We're also looking for feedback on the preliminary recommendations for fee increases for the MCLE provider and LLP fees. As the memo states, the comprehensive list of these recommendations for fees, reflecting the committee's input, stakeholder input, and other comments will be brought back in May of 2023. So this is going to come back before September. The current plan is to bring this back in May of 2023. Both the Board of Trustees and the Finance Committee will be asked for their approval. The timing will allow for meaningful comment, and it also be the conclusion of the California State Auditor's audit of use of mandatory licensing fees that's currently underway. The audit may inform both staff's fee recommendation and the committee's deliberative process. So, and as Leah said, some of these fees will need to go to the Supreme Court, and that would take place after the action of the Board of Trustees and the Finance Committee. I'm now going to turn it over to Lawrence Lau and Andrew Conover, who did a bulk of the work to give the presentation on these fees.
Very good.
Lawrence.
Once we can see it on the screen.
I'm sorry, I was on mute. I apologize. Thank you, everyone. Thank you, Justin, for that introduction. And here is the fee review update, so to speak. We have all.
Lawrence, I think we're seeing the presentation mode, not the full.
Are you not seeing the presentation?
Yeah, we're seeing
it's
the
in presenter mode, Lawrence.
Oh,
yeah.
Okay. Hold on 1 second. Let me try to fix that. I apologize.
Problem.
How is that? Does that fix everything?
Yeah.
Okay, great. Thank you. Yeah. Thank you, Justin. So we are going to now review the current state of the fees that Justin had just spoke to just a minute ago. How do I do this? Okay, so here's the overview of the agenda item. No action is required today, and we are asking to review the final recommendations from the offices for the certificate of standing, the MCLE compliance and law corporations, as well as present the preliminary recommendations provided by the offices that are pending feedback from stakeholders for the MCLE provider certification and the limited liability partners fees. And to remind the committee that the final recommendations are due in May, are scheduled to, we would like to schedule to get final recommendations in May to, number one, reflect any feedback from stakeholders, as well as allow the completion of the current audit by the California State Auditor. Just to get right into it, so for the certificate of standing, the current fee is $25, and we'd like, and the proposed increase is to $40. The main reason for the change is it's currently there's a current operating deficit that exists. And for the MCLE compliance portion, you can see the late fee we want to increase from 75 to 100, the reinstatement 200 to 300, the credit request 25 to 100, and the EMOD 75 to 100. And for the reasons of it's generally running at an operating deficit, as well as enhancing performance and functionality of the program. For law corporations, there isn't a deficit, but there is the reason for the increase is to enhance the performance and functionality. We want to increase, the proposal is to increase the fee applications from 200 to 250, the renewals from 75 to 100, and the late fees from 110 to 150. And so these are the final proposals. These three are the final proposals from the offices that they are presenting. And then the next two items are the proposed changes for the MCLE provider certification, as well as the LLP. So just to provide the summary of the changes proposed are eliminating the distinct legal specialization fee, reducing the MAP renewal cycle from 3 years to 2 years, increasing the SAP and MAP fees, the introduction of a nonprofit rate, and then adding an SAP and MAP late fee, as well as a reinstatement fee. And for the LLP program, the proposal is to remove the cap of roughly $2,500, and then we have two options under consideration. Both removing the cap, but then one would be to not increase application and renewal fees, and the other would be to modestly increase the application and renewal fees. And just to point out, approximately 100 law firms currently benefit from this cap structure. And then to sum up the impact of the fee increases for these two offices, ARCR and OPC, when you look at the entire program in a consolidated view, you can see the current, they're running at a current deficit of roughly $917,000. And with this recommended fee increases, you can see if we go with the option A for the LLP, it would put them in a position, these programs in a position of positive 860,000, and with option B, a positive position of 900,000. So you can see the net change of roughly 1.6 million to 1.8 million if these current fee recommendations are instituted. And so we can also see holistically, not all the fee increases gets to a net, positive position, but some of the other fees will help lighten the load, so to speak, on many of the programs that the offices do not feel comfortable increasing fees to offset all of the expenses, but to narrow the gap instead of bringing it back to a break-even point. And that is just the quick summary of the state of where the fees are. just to summarize again, there were the 3 fees that have a final recommendation by the offices, and then 2 that are out for stakeholder comment. Are there any questions?
I have a few questions.
Broughton.
I guess one of them is kind of interesting. At some point, if we vote on these fees, do I, as an attorney, have a conflict in as much as I end up having to pay these fees one way or another? I have a question about the for legal specialists. There's also a separate fee that wasn't included in any of these, though I did notice on one of your slides, it talked about the elimination of specialization fees, and I wasn't sure what that meant, other than perhaps the extra amount that one pays for the MCLE credits. So I was just curious about that. And then is not in the fee bill, is not all of these fees, or are not they approved by the legislature? So,
I'll take some of those. These fees are not statutorily set, none of them. We outline in the memo which ones do, however, require Supreme Court approval. Some Law Corp and LLP, namely, in this agenda item. 2, there's no proposal to modify legal specialization fees. The fee that is legal specialization related that's referred to in the agenda item is for the MCLE providers who wish to be certified to provide legal specialization credits. The proposal on the MCLE provider piece is to eliminate the add-on legal spec fee. So this is not a fee that's levied on legal specialists, but rather on the providers who seek to provide legal specialization credit. Your first question, that's a question for Aline. I think every lawyer on the board then would have to recuse themselves because they potentially might, need a certificate of standing or be late or non-compliant with the MCLE, their own personal MCLE compliance certification. So I don't, my assumption is the answer is no, but I don't know.
We plan, before this item is being brought, will be brought to the board or the committee for actual action and vote. Brady and I, we had on our list to actually conduct an analysis and reach out to all the board members that would need to abstain from voting on the items. Because it may not be blanket. Some attorneys may be impacted more and some may be impacted less.
So for example, I know that when the legal specialization issues come before the board, and I don't know if the amount of fees for that is set by the board, any of those issues, I abstain because I am a legal specialist. So I'm just curious about, since I do have to pay those fees, as do the other attorneys that we set. I mean, theoretically, I could say, I don't want to pay any more fees. I vote them down.
Oh, that's a great question, and that is something that was on our radar to do and reach out separately to the board members prior to any action item.
Thank you. I just had an ambulance go by my office here.
Mr. Broughton, are you good?
Yeah, I'm satisfied. Thank you.
Mr. Tony, I think I saw your hand.
Yeah, I want to respond to the question brought up by Trustee Broughton. I think that it's possible to, that with full disclosure, I mean, part of conflict of interest has to do with when people don't disclose things, okay? But the fact that there's disclosure that that there are attorneys on the board that pay these fees, so that's one thing. The other thing about conflict of interest is there's also a threshold amount, okay? So the changes that we're talking about, $100, okay? I think you can look at the conflict of interest and there are certain thresholds, like Form 700, establishes certain thresholds of amounts that are considered material. And so I think that I would just encourage the general counsel to look at the letter and spirit of conflict of interest, because I think it would be an absurd outcome if attorneys on the Board of Trustees could not vote on this issue, because it could lead to this being applied to other issues. And I appreciate Trustee Broughton bringing this up, but I know from my standpoint and my understanding of conflict of interest, I think through a combination of disclosure and a clarity and an acknowledgement of what amounts we're talking about for individuals, I think there's a way to err on the side of inclusion instead of erring on the side of exclusion, as long as it's clearly delineated, public, disclosed. So that would be my own personal view that I would like to make a pitch for. Obviously, we have to let the general counsel do the background that needs to be done. And I respect that, but I just wanted to weigh in on my view on this.
And that's the reason why it's a case-by-case analysis, and it would depend on each one of the board members.
Terrific.
Very good. Other members of the committee, Mr. Tony, you have?
I have some substantive questions on this. First of all, what is SAP and MAP? I have no clue.
Mr. Tony, SAP is the single activity provider and the MAP is the multiple activity provider.
Okay, it probably was in there somewhere, but I don't always, I can't remember everything. So, okay, so thank you for that. And this will not be voted on now. Okay, here, let me tell you my main thing. I would like this proposal when it comes up. The very first sentence says, pursuant to a policy adopted in 2017, okay, the State Bar is required to assess the fees every 5 years. 5 years is way too long. Like, for instance, I was not on a board in 2017. I don't think most of the people here weren't, most of us trustees were not here in 2017. Okay, perhaps Trustee Broughton, but the rest of us, okay, thank you. I do acknowledge, and I don't want to leave you out here. But, and so it's just too long. Plus, if we make a decision in 2023, well, by my count, that's 6 years from the last time we've actually made a decision on this. So I want to know what's the procedure for me asking that this be done every 2 years? Can it be part of the resolution that comes to us in March? Does the Finance Committee need to take a vote on it today saying that's what we want to see? If other people agree with me that 5 years is just too long to go reviewing, what's the procedure here? I need some guidance.
I think you could adopt it in a resolution, and that policy that we're referring to, I think it's an internal policy. So we could also consider amending the board book to include this in the Finance Committee's charter. That's the way to, I think, institutionalize it, ensure it's done sort of in perpetuity beyond any particular board member's tenure. I would say that, not speaking for finance, but I think the concern is that's too frequent, just because it's a tremendous workload involved. That being said, at this point, I'm not really disagreeing with you. So I think we may need to have a different approach that's a bit less labor intensive, because to make it viable to do it with more frequency. So I think when we bring this back in May, we could bring back a resolution and a proposed amendment to the Finance Committee charter.
Thank you.
More from you, Mr. Tony?
I'm good. Thank you very much.
Mr. Knoll, anything from you? I do have a couple of questions myself. And one is, Lawrence, I don't know if you can bring up the last, we may not even need it, but the last slide, the one that shows where there are some some of the funds that do have deficits in them. And my question was just on fungibility. And I think what I took from your comments is that even though some of the, like the lawyer referral service and the mandatory fee arbitration, that those are in deficits, that given the nature of, I guess, maybe the overall account, there's fungibility between each of these line items. And so those other line items where there are positive balances would address where the deficits are.
Right. I think my understanding is, for example, for lawyer referral service and mandatory arbitration fees, those two programs are generally considered a kind of a public service, so to speak, or public good that wasn't necessarily designed to offset, the fees weren't designed to offset the costs of providing those services. And so those are some of the reasons why the office did not feel comfortable raising those fees significantly. And so when you look at all these programs holistically, as an office or consolidated, you can see some of the other fees that we consider to raising, including law corporations and LLP, is to offset, right, some of these deficits and some of these other programs to kind of balance themselves out. So that's kind of the logic behind it, the thought process.
Well, just to add a little bit, some of them, the two Lawrence called out, mandatory fee arb and lawyer referral service, they are also undergoing a fairly extensive review of their programmatic design. And so it would be a bit premature, I think, to raise the fees. Lawyer referral service, I believe, also we have a statutory limitations on what we can charge. I know Brady had his hand up earlier. He is the key OGC guru on fees. I don't know if he wants to say anything. He should jump in maybe, because I can't see him. But so it's not just sort of a public service rationale. It's that some of these we're not ready to propose fee adjustments. I do want to be clear, however, when we start talking about our budget, which is the next agenda item, overall in the general fund, we are operating at a structural deficit with no sort of end in sight to that. So to the extent that we can maximize fees for service that we're charging, we should. That being said, we also need to be reasonable and realistic about how much we can increase any given fee. Even if we're operating at a significant deficit with respect to that program area, we just can't, increase fees by 300% and 400%. It's not viable. So there's all of those different considerations at play.
Understood. Two other quick questions from me. I know this is a discussion item only. You'll be bringing this back in May. And per the interaction between you, Ms. Wilson, Mr. Tony, just in terms of cadence, one of the things that sort of struck me is that if this comes back in May, that would be for 2023, that these would go into the fee increases if the board so chooses to increase the fees. Those increases would go be effective in 2023. I may be confusing this a little bit, but Mr. Tony's prior question to Ms. DiLoretto, she said that in September would be a good time for us to be reviewing fees. And so would we be doing 2023, May for 2023, and then turn right around in September, be thinking about 2024? Or I may just be confusing that a little bit in terms of how she was talking about how that whole conversation around cadence went. You follow me?
Yeah, I do. I think this is what I think. There's no time that's too early to start talking about fees for the subsequent year. So there's no reason we can't talk about 2024 fees in May. I think one of the issues and our takeaways as a staff team from this conversation needs to be that we need to take a look comprehensively at that schedule of fees, setting aside things that require statutory approval. But so that when we're bringing something back to you, it is comprehensive. We have addressed some of the issues that Mark raised in the previous item. We have a comprehensive set of schedule of charges and fees. We could do that in May, or we could do it in September. So I think, we can figure that out. And only some of these would go into effect immediately. Some would not go into effect, even if you vote on them in May, until 2024, because they have to be incorporated into the whole billing cycle. This not true for LLP, LLC, it is true for others.
Very good. Last question, and I do want to move on, and that is, would it be imprudent for me to suggest that since we're going out for public comment for 3 of these, and there's 2 that I guess we are sort of the staff has made a final recommendation, would it be imprudent just to say, why don't we just send them all out for public comment? All 5 of them? Or is there some distinction between why it is that we don't need to send the other 2 out for public comment?
I don't know. Finance folks, do you have any thoughts on that?
I think the genesis of the public comment is the 2 programs that the recommendations, the preliminary recommendations are the most drastic. And removing the cap for LLP is a big change, and it affects people disproportionately depending on how large their collective partnership is. Whereas certificates are a fairly simple program that's used occasionally. It's not, the impact to the stakeholders are not deemed as great.
Very good. Well, we will, unless there are others that have any sort of questions or comments, let's move on and let's leave it as it is in terms of the structure of the public comment. All righty. I don't think we need to take any action here since this was just a discussion item. So let's move on to the next item, which was under regular business, which would be item number B, approval of the 2022 third quarter financial statement and investment report. Are we ready for that one, Ms. Harvey?
I think we have one before that, don't we?
No, that is correct. This is the item that the chair just expressed. So we are at the approval.
The request for the 2023 spending pending formal adoption of the budget. That's what I have as for B.
You want to know what I see. I was looking at Ms. Harvey. I think we may have flipped them in the presentation that on the presentation doc, and I see item number B on the agenda is flipped. Okay, not a problem.
Okay.
So let's take up the request for 2023 spending authority pending formal adoption of the 2023 budget. Very good.
Sure. I'm standing in for RSLE again. So the State Bar's annual budget is generally adopted in January, and then it's filed with the legislature by February 28th of every year. State Bar staff need authorization to spend for the period of January 1st, 2023 through the board adoption, which will take place at the January Board of Trustees meeting. Approximately 1 month's worth of expenditures in the amount of $105 million is expected to be incurred in January 2023. Of the makeup of that $105 million, approximately $92 million of those expenditures are grants disbursements expected to be paid in January of 2023. So this is significantly larger than what we requested last year, and that's because the grant disbursements is significantly larger than in the past. In order to come up with these numbers, we made certain assumptions about what is going to be included in the budget. We made an assumption on the COLA. We identified funding to support the Office of Chief Trial Counsel implementation of case processing standards. We've identified the priority for the information technology support. And then we're also trying to minimize deficit spending in the general fund through various objectives. So we are requesting that the Finance Committee authorize this spending for January 1st, 2023 through the adoption. Are there any questions? Yes, Trustee Tony.
I really appreciate the breakdown, and I think you said 92 million approximately in grants. Is that correct? Did I hear you right?
That is correct.
Okay.
That is correct. We have a lot of grants that are one-time disbursements. We have, our IOLTA grants are quarterly, but there's a lot of homeless prevention grants and other grants that we have that are all dispersed in January.
Okay. Given that, I see that the 105 minus 92 equals 13 for others. And what I would like to suggest to give you wiggle room is to say not to exceed 93 million for grants and not to exceed 13 million for other expenses. That's how I propose to amend the motion, because 105 million is for a single month an extraordinary amount. Justin, however, explained why we need it. So I think we should split out the grants. So what that means is that if for some reason that they only 60 million goes out the door and 30 million is late and goes out in February, it doesn't mean that there's overspending in other parts of the budget. So that's, this is actually doing what is being requested, but just being a little bit more specific.
Okay, that sounds like a modified resolution.
That's what I'm proposing.
All right. So Mimi, are you drafting that proposed resolution? Right. We need to modify it to reflect Mark's amendments. You could do that and strike through. So maybe Justin, you can walk her through what it should say.
Yeah, I not to exceed, I think at the end, we just cross out the 105 million and just put not to exceed 90. Did you say 92 or 93 million?
93, because
93 million.
92, I know it means a change.
93 million in grant expenditures.
And 13 million in other expenditures. It gets you up to your 105. It actually adds up to 106. So I'm not trying to cut you down, but I think this is important to specify because the 92 is such an extraordinary expense for a single month. It is not typical.
Okay, that was 93 in grants, and what was the other?
And 13 million in other expenses, operational expenses, whatever, however you want to call it, other or operational, it doesn't matter.
Let's just say other.
Other is fine with me. I haven't cut down what you're asking, but just specified it a little bit.
Okay, is what you see, is it correct?
Need the dollar sign in front of the 13.
Okay.
So this is a motion that Mr. Tony has made, and I'm going to need a second on that. Can I get a second on this, please?
I'm not necessarily opposed to it, but I'm curious as to why we need it. I don't quite understand that.
The spending authority altogether.
Yes, instead of just having the 105 that we had before.
Oh, you mean the specific delineation? I think
So
that's,
let me ask a question. What is the total budget for annual budget for the state bar approximately?
Approximately 250 million.
Okay, so 250 million for 12 months, and we're being asked to authorize spending 105 million out of 250 in a single month, 1/12 of that time. I am okay with that as long as it's explained, specified. Otherwise, I don't think it's fiscally responsible to approve. This is pending adoption of the budget.
But it is specified in the underlying documentation, is it not?
so maybe Mark Broughton won't be the second. Is there?
Yeah, I'll be a second. It's just I'm not completely convinced as to why we need this amendment. I don't see a problem with it, but I guess I'm just curious about it.
Any further discussion on this? Thank you, Mr. Broughton, for that. I understand somewhat reluctant second. All right, Ms. Harvey, would you call the roll, please?
Broughton,
Would that be a somewhat reluctant yes?
That's, we'll take it, we'll take it.
Yes.
no,
Yeah.
select absent, Tony,
Aye.
3-4, none against, motion carries.
Very good, very good. And just to clarify that at our February board meeting, is that when we're gonna do the January? The full budget in January, okay.
I did want to say, Trustee Soul, that I do think I will need you to ask the Finance Committee to have a special meeting between now and the January board meeting to focus on the 2023 budget. Because as we kind of alluded to in the agenda item, it's a very tight budget. We are operating at a structural deficit in the general fund. We do not have a licensing fee increase anywhere on the horizon. And so I think we're going to need some extra discussion and focus on the 2023 budget. So we'll be asking the folks to give some of their time to that effort, probably at the very beginning of January after we come back from the holidays.
Very good. I see Mr. Hernandez.
Yeah, just a quick point of clarification. If I understood correctly, we voted on an amendment to the motion, but have not yet voted on the motion itself. So I think if we would like to move forward with the motion, I just wanted to point that out, that we haven't voted technically on the motion itself as amended.
But you know, I didn't introduce it as an amendment. I introduced it as a motion. This motion was never put on the floor. So that's why it doesn't need to be amended. It's not an amendment. No one ever moved and seconded this resolution. So the resolution I made was the main motion on the floor. That's why I think we're done.
Got it. My apologies.
Not a problem, but that's how I understood it as well. So, all right, let's move to our last order of business here, which is the approval of the 2022 third quarter financial statement and investment report. Justin,
Correct.
is that you again?
It is me again. I am sharing my screen. Can everybody see the screen?
Yes.
So we've provided the agenda item that goes into detail, but I will just cover some of the highlights from the agenda item. The agenda item itself includes our 2022 quarter 3 financial statements and the 2022 quarter 3 investment report. The financial statement highlights, I'll go over the revenue highlights at first. You can see that the revenue for the general fund is up about 2.4 million over budget, so that is good. Some of that is due to increased licensing fees over the forecast in the budget. There was also a legal match settlement that was received to make up some of that money. The rest of the funds you will see are generally on budget with the exception of the Legal Services Trust Fund. Legal Services Trust Fund is higher than budgeted, and that we've talked about this previously, but the daily actual balance in the IOLTA accounts was 4.2 billion versus average budgeted balance of 3.4 million. So in those accounts, there was more money. And then the interest rates for those accounts are starting to catch up from the Fed increases. The interest rates, we budgeted a 0.68 way back when we were developing the budget, and in August it was 1.42%. So the yields on those accounts is higher. So that's why you'll see significantly higher in that fund. And the admissions fund had a little bit more due to more registrations at the February bar exam. So that is on the revenue side. On the expenses side, you will see that we are under budget, which is good by about 6.7 million bar wide. About 1.2 million of that is in the general fund. There are personal savings from staff vacancies. This is in addition to what we have a vacancy rate that we budget in, but this is on top of that. And then there are building operations. We're planning to sell the building in San Francisco, so there's slightly less spending on those. The rest of the expenses you see are pretty much on budget. There's little savings in the admissions fund. There's the other large savings is in the client security fund, and this is actually due to claims not eligible for payment. So we have a certain amount that we set aside every year for payment, and we just don't have the eligible claims at this time. So that is overall on the expenses. I don't know if there are any questions about the revenues or the expenses before I move on.
I just have kind of a crazy question. We had a bunch of people pass the bar exam, and I'm assuming that they're going to be paying their fees here shortly to get their license. Do we budget for that? I mean, we have no idea of knowing who's going to pass or how many, and whether and what the amount that those people are going to pay. Is that somehow included in our budget, or like does it go to next year, or what happens with that?
Yeah, the Office of Research and Institute Accountability does a forecast on the licensing fees. And so we have to forecast the number of people that would potentially pass the bar, but also the people that will be retiring from the practice of law. And so whether or not those things will be equal. And this year we were very conservative in what we forecasted and thought that that would be about neutral, the amount of people leaving the bar versus the people passing and joining the bar. And actually, that's where the 1.2 million in additional revenue came from, is that we did have a growth. So there were less people that left and more people that joined, or some combination of that. So we do take that into account.
Thank you.
Other questions on the financial report?
Okay.
Mr. Tony?
Then, oh, sorry. Sure.
Go ahead and finish.
I was going to go on to the investment report, but if you have questions about the...
I do. Thank you.
Sure.
So let me see if my interpretation is correct. Revenue for the first 9 months was 251.9 million. Is that correct?
Correct. Or actual is 251.9, correct.
251.9. And expenses for the same time period was 220 million.
Correct.
So that provides a net gain or a surplus of 31.9 million.
As of right now, yes, that is correct.
Okay. So first of all, I think that's good news. Anytime you end a quarter with more revenue than expenses year to date, that's positive news. My only comment is, I think it would be appropriate to include in your report just that math, because not everybody does the math. You know, just a total revenue, total expenses, and what the difference is, surplus or deficit. So that's one suggestion to add to this report, because it's actually quite encouraging news. I think that the other two quarterly reports reflected deficits. So to make a turnaround is a plus. And I guess what I want to know is, are there going to be extraordinary expenses you anticipate in the next 3 months that will reverse this back to a deficit? Or what should we expect by year end?
And so we can definitely add that to the slide, but there is a word of caution on that. We receive most of our revenue in the first couple months of the year. So the revenue coming in the last 3 months of the year is pretty much stagnant, because we get the licensing fees, which is the majority of our revenue, is due by February. So we're not anticipating getting a lot of revenue in the later part of the year, but we do have continuous expenses. As you saw from the previous agenda item, it's about $13 million a month It's maybe not that high this year, but if you do another 13 million times 3, we start to get into the deficit territory that Leah was talking about. And so that's why doing that is good, that, you know, we are positive at this time, but because our revenue isn't over 12 months, it's very front loaded. It doesn't necessarily paint an accurate picture because we do have expenses that go to the end of the year, and we do have some of the expenses we anticipate that haven't been spent yet will be spent in the fourth quarter of this year.
Okay, that's good to know. There's some of that is reflected in your year to date. So when you do year to date budget amounts, you don't simply take the year and divide it by 12 months, do you? I mean, I'm thinking you might incorporate some of those fluctuations into your quarterly expectations, the year-to-date budget, or do you just divide it by 4 for each quarter? I'm just curious how it's adjusted.
No, for most of it, and we're getting better and better at this, we do try and budget when the expense or the revenue will incur. And so for the revenue, we definitely budget it heavy in the front part of the year. That's why the budget is somewhat in line. With the expenses, if our total budget is 250 million, we've obviously not just divided it by 12, but we've kind of projected when those expenses will hit. And that's why it is good that we're under, if you're comparing to budget, because we do try and budget when we will incur the expense, that we're that 6.7 million under. That is positive.
Right. Okay. Well, I think that's, I still think this is very good news. And we'll see where we end up in the year. Thank you very much at the end of the year.
Okay. I will move on to the investment report if there are no further questions. All right. So we, our investment report, we're in compliance with our policy. We use Wells Fargo highly rated securities. I will note that the total market value of 110 million compared to 131 million as of September 30, 2021. This is solely due to the fact that a lot of our investments have matured. And so we are in the process of reinvesting them. A lot of that money is in a money market account, and we're identifying those investments where we can reinvest that money. So you will see that that number will go up in the fourth quarter. And then also the local agency interfund, LAIF, our market value is about 74.2 million. It has a maximum of 75 million that we can put in LAIF. And we are starting to see the interest rates in the LAIF account move up. It is 1.29% versus 0.22% this time last year. And even from the second quarter, it was 0.69. So you can see that interest rates are climbing fast, which will help our yield there. This is a summary of all the investments that we have. As you can see, the top line, that 3 million, those are what that number will increase once we reinvest a lot of those things that have come mature. The LAIF line is the line underneath that. And then the Bank of New York Mellon Trust, that is our loans that we took out for the certain project, the IT projects and building. And so those loans are earning interest as we are expensing. We go and expense the proceeds of those loans to pay for the projects that they were designated to pay for. So that is the end of my presentation on the investments. Are there any questions?
I don't see any. Justin, you want to move to the motion to move the quarterly report?
I'll move adoption of third quarter report.
Mr. Broughton, you want to help me out with a second here?
Yeah, I'm still having trouble with my button. Yes, a solid second.
Thank you. Harvey, would you please call the roll?
Broughton,
Yes.
Noel,
Yes.
select absent, Tony,
Aye.
3-4, none against. Motion carries.
Very good. If I am not mistaken, that includes the business before us today.
Yes, good job. Right on time.
Very good. So, Ms. Wilson, do I just, those of us that aren't on the audit committee will just sort of log off for now and okay.
Yep.
Very good. Thank you.
All right.
on this
Thank you. Bye.